So the big question is, can you copyright a crochet pattern? Is it cool if you rewrite someone else's pattern and distribute it to your friends? And as a designer, how can you ensure that your hard work is protected from infringement? We are going to be talking about all of those things and more today with our guest, Gordon Firemark. So welcome to Crochet Business Chat. My name is Pam Grice, a crochetpreneur. I'm on a mission to help 100,000 makers find financial freedom through crochet, and I am so happy to have you here with us on Crochet Business Chat. So if you're new here, go ahead and subscribe for Crochet Business tips and fun things and a great community. So I'm just going to get into it. You know, I don't like to fluff around. So I'm going to introduce Gordon, and we're going to get into all of the things about copyright. So Gordon Firemark, we happen to be in a professional group together of online business owners. And so that's how I found him. I was desperately reaching out saying, who knows anything about IP? And Gordon raised his hand, and I'm so grateful that he did because, you know, we're having some drama in the crochet industry. And so I was so happy to find him because he works with creatives, artists, entrepreneurs, and other business owners to help them achieve their dream of getting their message out and making a meaningful impact with their craft. So he is the perfect person for us to be chatting with today. He's also known as the podcast lawyer. He has 2 podcasts, I believe, the Entertainment Law Update and More, Better, Faster, which you might want to check out. It sounds like it'd be perfect for those of you who are building a creative business. So he's also the author of Podcast, Blog, and New Media Producers Legal Survivor Guide, which I'm thinking I need to go get a hold of that today. I hope you will too. So he has an undergraduate degree in radio, television, and film, and experience in live theater production, which is so fun. I think that that would be something fun to talk about on another podcast. And in addition to his busy law practice, he teaches entertainment law at Columbia College Hollywood, intellectual property and media law at Fashion Institute of Design and Merchandising, and contract law at Pepperdine Law University. So sometimes I think I'm super busy running my 3 crochet businesses, and then I see people like Gordon, and I'm like, I think I'm fine. He's got his hands in a lot of pots. So I'm so happy that he's willing to take some time out of his day to join us. And I'm glad that you're here as well to get in on this chat. So let me bring Gordon on. Hi there.
Hello, hello. Thank you, Pam, for having me. It's nice to meet you and your
Nice
audience.
to meet you. Thank you so much. Like I said, I'm so grateful that you're taking time out of your busy day. I know you said you just got your kids off to school,
Yep.
and you're ready to start rocking, chatting about copyright. So
Let's do it.
The funny thing with the term crochet pattern. So we're going to be using this term crochet pattern.
Yeah.
And that term has its own sort of set of complexities because a crochet pattern entails the idea behind the design. It entails the process of creating design. And then it also has the written words describing how to do the design. So as we're talking about this, if we can specify which, are we talking about an idea?
Yeah.
Are we talking about written words? And that way I think that we can help people decipher what it is that is covered by copyright law and what is not covered by copyright law. So can we start there? Can you help us understand the specific parts of a crochet pattern that are protected?
Absolutely. And in fact, thank you, because that was my first question when we started preparing to do this episode was, what do you mean by a crochet pattern? Can you send me an example? And when you did, it was like, aha, the light bulbs went on and all the synapses started firing at the same time. So let's talk a little bit about the basics of copyright. First of all, what copyright is this bundle of rights that give the owner, the author of the work, which we'll get into in a second, exclusive rights to copy and distribute and perform and display and make derivative works based on that original work. So in order to be entitled to copyright protection, the work needs to be an original work of authorship, of expression of ideas. As you mentioned, the ideas and facts are not entitled to copyright protection. We, as a society, we don't want to take words out of the lexicon. We don't want to take ideas off the table, and obviously facts. We want to be able to tell the truth without having to, navigate around these kinds of things. But the specific original way that you as an author or I as an author express the things that we are doing, that's what's entitled to protection. So the design of the thing that you're making, I mean, if it's a square pot holder, it's not really an original design, but the wine cozy design that you sent me, I think that does have some copyrightable elements. I'm not sure that the cylinder that surrounds a bottle of wine is, but the shawl collar or the bow collar, those kinds of things, I would think that is something that can be protected inherently in the design, because that's original. Also, the specific layout, obviously, of the pages that you write the design out and you create the pattern, that is something that's protectable. The photographs that you use to illustrate are certainly independently copyrightable works, and so together they are. And then the prose or poetry that you use to describe the work and your process and so on, that can be entitled to protection. But, and this is the important part, the actual mechanics of making the thing is not something that can necessarily be protected. I mean, there's a little bit of an except in there, but I'll come to that in a minute. But, that's like the recipe, right? And you've all seen, the recipe for chicken noodle soup is not something that we can protect. We want other people to be able to make it and make their variations and so on. That's why you see, and a lot of people get frustrated with, just give me the recipe. I don't need 6 pages of explanation about how much your family loves this thing. Just give me the recipe. Same thing going on here. The recipes are not protected under copyright law because they are essentially facts. It's a formula, right? A mechanical process, I guess you could call it. If you invented some kind of a new way of doing the stitches, maybe that would be something that might be entitled to patent protection or something. But no, that recipe for making whatever the item is probably not entitled to protection. Again, except insofar as it identifies the specific, the number of times around to make that shawl collar, for example, or something. That might be, anybody who copies that exact number and set of instructions, now they are essentially making a derivative of the original. But no, there's nothing wrong with saying, okay, now do a row of this, now do a row of that, use this stitch, use that, that kind of thing. So what we will see is, 10 different possible patterns for sweater for baby, with fundamentally the same, for a size, whatever size micro, we'll do this many stitches to get, a thing that's however long around or whatever it is supposed to be. So can you tell I don't do any crochet or sewing work?
That's fine. This is still super helpful. So yep, you're using the right words.
Okay. So yeah. So I mean, so with a very narrow sort of exception, that recipe, that formula or instruction set for the specific stitches and the number of them is not a protectable component.
Okay. So when you say derivative, what does that mean?
So a derivative work is any work that is created, that is based upon or incorporates the original. So if I was making I'm going to use the wine cozy as my example because it's the one in front of me. If I was making a whole picnic basket liner and I added in the wine cozy, maybe it's stitched into a corner, maybe not, that would be a derivative work because it incorporates your wine cozy design.
Okay. So we had chatted just before this about instances where someone might take someone else's pattern and rewrite it in their own words to share with people. What are the legal implications of that? Is that covered? Is it protected? What do we know about this?
Well, to the extent that it's restating the recipe, for lack of a better term, that's okay. To the extent that it copies the same, obviously if it uses the same photographs to illustrate, then that's infringing on all those photographs. If it's the overall, what's the word I'm looking for? The sequence of everything is exactly the same, and all that descriptive prose or poetry that I was referring to before is the same or similar, then it's not. But if it's been essentially just translated, well, translating into a new language is technically an infringement. But rewording, paraphrasing, changing up the order and structure and those kinds of things, it might be okay. This is one of those areas where I would refer to the copyright in the pattern as sort of a thin copyright, I would guess. So to the extent that it doesn't copy the same photographs and it doesn't copy the same layout and overall expression, then I think it's probably not infringing.
Okay.
And therefore sort of okay. Morally, it's not okay. And
agreed.
Even if you have the best intentions, I would say the right approach is get permission from the original creator so that there's no recriminations later on, as I understand is what's going on here. But there's more to this than just copyright, and it's important that we remember that when you go onto a website and you click on that thing and it says give me your email address and check this box, you're making a contract with the creator of the website, and that contract can specify to a certain extent what you can and can't do with the thing that you're getting. I'm not entirely sure we could totally restrict somebody's right to do what copyright law already allows, but a contract saying I won't do that, I think is valid and binding. The real trouble is it's hard to point to, as the creator of the original, it's really hard to point to how much money have you, if you're selling the thing, then yes, you can point to that. But how much money have you really lost because someone made their own version of your thing? I actually am going through this right now in my own world. Well, I'm not going through it. I mean, it's just a fact. But one of the things that I do to get people onto my mailing list is I offer a free podcast guest release where the guest is giving consent to be recorded and that it be broadcast, and I'm not getting paid, and you own the content and all those kinds of things. And I make it available for free. All you do is give me an email address and download it. Well, in one of the Facebook groups for podcasters, sure enough, just last night, some guy posted the full text of a guest release that is remarkably similar to mine in the sense that it follows the same structure and most of the same wording. He actually left out some important language, and that's what I've been pointing at. Hey, there's something missing here, dude. Maybe you want to use the one drafted by the lawyer. But but honestly, could I do anything about it legally? Probably not, because it's not a recipe, but it's a set of sort of standard language expectations of things. So this is definitely a tricky area, and if I put in my terms of use, thou shalt not copy, I think that would have some force and effect, but you're not going to stop the person who's determined to make a copy.
Right.
So
right. It's so sad.
You know what I would suggest for folks that are making these kinds of patterns is watermark all your images.
Okay.
Put a watermark there that just shows where this image originated, and put it somewhere where it's not easy to crop out of the frame. So that if anybody does copy those things, the viewers are going to know, oh yeah, that's came from so-and-so.
Okay.
Yeah. I think that's an important way of protecting yourself. Yeah, I'm sorry. Go ahead. I'm sure you have some other question.
Yeah. So my other question. Sorry, I think we may have just lost power. I have a
Oh,
USB. I have a uninterruptible power
uninterrupted
supply.
back. Yeah.
So um, hopefully that will cover us. Anyway.
Well, Pam, if you disappear, I'll just keep going. So
Okay. Perfect. Um, what can you explain the fair use doctrine and what does that mean and how
yeah,
might it play into some of this type of issue with crochet pattern
yeah,
design?
that's a great question. So here in the U.S., we have the First Amendment, freedom of speech, which is a constitutional provision that basically says government can't make laws that infringe or impair a person's rights of free speech and expression. The copyright is also covered in the Constitution. There's actually a clause that says Congress may make a law giving authors and inventors exclusive rights.
Mm.
So we have these two conflicting constitutional provisions. And in the early part of the 20th century, the courts started having to grapple with this because people would say, well, I want to use that expression. I want to say those words or whatever. And that's infringing my right of free speech to give someone a copyright over that. And so they developed this 4-part balancing test, 4 factors that you have to consider. They are the nature, the purpose and character of the allegedly infringing work, the nature of the original work, what kind of thing is it, the amount and substantiality of what's taken, and the 4th factor is the sort of commercial impact, the impact on the market or value for the original. And there's no rule of thumb. We have to do this analysis every instance of potential infringement. To copy the pattern, again, if they're copying a photo, unless they're probably copying most, if not all, of the photo, right? So that's a full infringement of that one copyrighted work. If they're copying the wording of a paragraph of a 10-paragraph thing, maybe the amount and substantiality isn't enough to rise to the level of infringement, and that's what we would call a fair use. But they're both, the nature and the purpose and character of the original, the infringing, is really the same as the underlying original, right? So that those factors are going to weigh in favor of the original, the copyright side. And then that market impact, again, if it's a freebie, maybe it doesn't have a very significant market impact. Although I think we could point to the value of a name on a mailing list, or
ad revenue,
or also the value of the right to say no to somebody making a copy or derivative or something like that. So, it is part and parcel of exclusive rights that the owner can say no and doesn't have to let you make a copy.
Sure. It's complex. It's a lot of stuff.
That's why we have law schools.
Yeah, right. And why it takes so long to get through, right? And the tests are so hard.
Right. Well, and 30 years practicing doesn't hurt either.
Yeah.
So
what would you recommend to a designer? What steps to take after they create their thing? That, like, we know, like, the written words, right, are they come with sort of automatic copyright protections.
Yeah.
But there are steps you can take to get kind of more solid, maybe not so ethereal protections. What would that be?
Yeah. So you hit on something I should have mentioned earlier, and that is that copyright protection does occur automatically from the moment the work is fixed in a tangible form. So you write down that pattern, you make those photographs, you own it right then. There is a registration mechanism where you can, here in the US, there's a registration mechanism where you can file a copy of the work and an application form with the United States Copyright Office, which is actually part of the Library of Congress. So your work then becomes a part of the catalog of the Library of Congress. And you pay a fee. It's, I think, $65 per copyright. And you wait a while for the government to churn its thing slowly as they do. And then you have a certificate that shows that you own the copyright. Now, that certificate, it establishes when the work was, first registered, but also you need that registration in place if you're going to sue somebody for copyright infringement. I'm just going to put this out there. I don't think suing somebody who copies your crochet pattern is a is likely to happen very much. Let's face it.
Right.
Filing a copyright infringement lawsuit is starting an odyssey that can easily get into the 6, maybe 7 figures. So there is a small claims court for copyright. I call it a small claims. It's called the Copyright Claims Board, and they handle smaller matters sort of informally through emails and things, and through the mail. And that might be a thing, but so far we haven't seen anything mostly photos and music or what we see happening in that.
Okay.
But yeah, so the registration is useful because if you have registered prior to the infringement and within 3 months of first publishing the work, you can get your attorney's fees paid and you can get statutory damages, which starts out at $750 per infringement and rises all the way up to the level of, if it's a willful infringement and really egregious, the court could award you as much as $150,000 for an infringement. So that may be where some teeth exist here if you're going to register. But if you're putting out a new crochet pattern every month, that $65 or more often, that $65 per starts to add up, and you don't know which ones are going to get infringed, right? So,
right.
Anyway,
so it's a sort of a calculated risk where you decide what if you have multiple patterns that do go viral that kind of tend to be copied, maybe it's wise to, and like if you have it set up in such a way that you're like, I know I'm going to make my $65 back on the first day of sales, then I'm cool. Like I'll just build that into my business model and not worry about it. But if you're a new designer and you're just struggling to make a couple sales and they're $5 a piece, then maybe wait and see how things go.
Yeah, I mean, I would suggest, in addition to the registration, that some of the easy things to do is, first off, put the copyright notice in the footer or at the somewhere on the pattern itself, but also on the website where you're offering either the freebie or the for sale. I would put a check. Well, first put the terms, including you're not going to copy, you're not going to distribute this pattern without my consent, those kinds of things, and a checkbox that says I understand these terms, so that there can be no, it's not just, oh well, it's understood that this is going to happen. It's like I actually saw it and said yes. I think that's important. Now, one other little wrinkle that this in preparing for today, I did a little digging into the crochet copyright community, and there's another issue that I've seen is that people get upset when their pattern is used to make something that's then sold on Etsy or on some other marketplace, and people take the view that, well, I'm distributing this pattern so you can make one for your personal use. The truth of it is, what somebody does with that pattern once it leaves your hands and into theirs, it's their pattern now. I mean, it doesn't mean they can make copies of it, but can they make multiples from that pattern? I'm not entirely sure there's any way to prevent or restrict that. And once I have an item in my hand, whether it's the pattern itself, or in the case of the case came up in the world of books, of course, that once the book belongs to me, if I want to sell it to somebody else, I can do that. It's called the first sale doctrine. And so I think there's a similar analog to, okay, I've made this thing from your pattern, I'm going to sell 10 of them on my online store. I don't think that there's any rule that we can cite that would say you can't do that, again, unless it's in those terms on the website that you check the box.
Okay.
I do think it's appropriate to give credit where credit is due for the pattern, and maybe you can insist on that in those terms as well.
Yeah, it's one of those things that still comes back to it's kind of like they can ask you to please don't sell the finished product, but they don't have the legal. There's no legal thing that says they can't sell their finished product in the U.S. I know in the UK.
Again, if there's a contract that says you're not going to sell it, then selling it is a breach of that contract.
Right. Okay.
Now, what are you going to do about it in terms of courts and things? Is it really worth going to court over?
Right.
But you can certainly recognize that somebody's breaching these contracts and then block them from downloading more of your patterns and those kinds of things that make it harder for them. And I'm never a big fan of publicly shaming people because you can get into getting sued back for false information, you know, defamation or invasions of privacy and things like that. But yeah, there's a lot that can be done.
Yeah, I think that's something important to cover as well, which is not really so much part of the copyright thing, but what happens when, I guess it is, because my next question was, what advice would you give someone that they see someone doing something that they don't like with their design? What suggestions would you give to them? And sometimes what we see is, you know, reaching out and sending a cease and desist or a request to take down or something like that. And then that sort of snowballs as soon as someone takes that online, that it snowballs into an ally gathering, dogpiling, bullying sort of online situation. So how can we prevent that? Or what are the best steps to take to when you think that someone might be infringing on your stuff?
Well, I mean, it's really hard in this day and age because of what you were saying. It snowballs very quickly. So my preferred approach, and I work with my clients who have these infringement issues of one sort or another, is I always encourage them to start with the notion that, you know, you catch more flies with honey. And so you start out nice and polite and you say, listen, I'm sure you didn't realize, I'm sure you didn't mean to do anything wrong, or I might even say anything wrong, but I'm sure you didn't mean to sort of cross a line, but these are the rules that I've laid out for when people download my thing. And it was clear because you checked a box. So would you please take that down? Or would you please not do this again? Something like that. And just sort of, you know, I'm sure you understand this is how I attract people to getting on my mailing list, so I can make other offers and provide value to the community. You know, you sort of make your case a little bit that way, but in kind, understanding, polite language. If they say, screw you, I'm not gonna listen. Well, maybe escalating and the formal cease and desist, and it's just a letter really just saying, hey, if you don't stop, I'm going to do something. And you have to decide what's the real threat in there, and are you willing to go the distance if they don't comply with your demand. The other thing about sending that cease and desist, you know, send that polite letter, it's less likely to be a problem when they post it on their website for the whole world to see. Hey, look at this letter I got, right? But when it's a nasty gram, as we refer to cease and desist letters, and they post it, now that starts to make you look like a bad guy in things. So that's the kind of, I'll call it a public relations play that you need to think about is coming across the right way. But you do have to stand up for your rights. Otherwise, sometimes you end up losing them altogether. And so in that polite letter, it's also, I'm sure you understand, I have to look out for my rights here. So I'm asking, you know, let's make a thing, or please make sure I get attribution. That's the other way to kind of soften the blow that you feel. But if they don't comply with the cease and desist letter, then, you know, maybe, like I said, I would use technology tools to ban them from downloading other patterns from you and things like that. Maybe even sort of publicly say, I've had a problem with people doing this, so if you do that, I'm going to ban you from the downloads. You have to have a webmaster who knows how to do that. And,
you have to figure out IP addresses and things like that, probably.
Which isn't really that hard, but it's something I think most creative people aren't really that interested in chasing down. You know, or call a lawyer and have a conversation about whether it's something worth doing. But now you're spending hundreds or thousands of dollars to go after that lost email address or lost $25 or whatever it is. You know, so it becomes just a straight up business judgment.
Yeah. Can we talk a little bit more about what you mentioned of, like, we need to protect our rights, the rights that we do have. There are implications to not asserting those rights or not protecting those rights. Can you talk about that just a little bit?
Yeah, it's less of an issue in the copyright world where we put a copyright notice on the work and we we trust that anybody who gets it is going to see that notice and understand the implications. But there are two principles in the law. One is technically what's called they're both equitable principles. Equity and law used to be separate systems of justice. The equitable principle called laches, Laches, basically stands for this idea that one who sits on one's rights relinquishes them after a while. So you can't just let everything happen and let everything slide all the time, and then randomly decide, well, it's Tuesday, so I'm going to go after that guy, right? And that the analog of that, or similar principle, the more modern terminology for that principle is called equitable estoppel. Estoppel means that one is prevented or estopped from taking certain kinds of action and or succeeding with certain kinds of action. So and ultimately equity comes down to, is it fair or not? So everybody else is doing it and I did it and they came after me. Your Honor, it's been going on for 10 years. Equitable estoppel, please. They shouldn't be able to come after me, I'm being singled out, those kinds of things. It doesn't always work, but that is a defense in these scenarios. So that's why I say you do have to police your ownership of things. It's sort of like putting a fence around your property so that you don't make it easy for people to steal.
Sure. And so I think you probably see a lot more of this in the trademark realm,
yes,
where people have their business name or some sort of product line or something like that trademark.
10 podcasts with the same title.
Yeah, that's awesome. Yeah, I have to every once in a while go looking. I just do a little search for Crochetpreneur because I have that trademarked. And there's so many people that are like, Crochetpreneur 1.
Oh, really?
Like, no, that's not cutting it.
Yeah, so that's where you send them that catch the flies with honey approach first will serve you well, because you're being polite. You're saying, well, I'm sure you didn't mean to, but here you got to understand confusion is still a thing. And we have to stop it.
And recognizing that third parties don't always know that you have that trademarked.
Well,
so they're just like, oh, I like that word.
Yeah,
right, for sure. It's one of the first things I have my people do when they're starting their business. So let's see. I'm going to go look and see our comments to see if anybody has any questions. I've seen patterns for things like the Grinch and Disney items. How does this apply?
This applies in the way that my advice is going to be: don't do that. The Grinch is a character that is owned. I don't know if that's a Disney tie. I think no, that's Dr. Seuss originally, right? So Theodore Geisel Enterprises. Is it weird that I know his real name?
No.
Okay.
Especially since you have kids.
Right.
They always have Dr. Seuss Day at school, right?
Yeah. So, a design like that, a copyrighted, it's not just a copyright, it's probably also a trademark for the Grinch design. You make a pattern that incorporates that, you are infringing that design. Absolutely. And you can expect to hear from them pretty quickly if you're doing, again, you're making a sweater for one person, not a big deal. It's not going to, you're not likely to hear about it. But if you distribute the pattern, or if you make 100 of them, now you got an issue. This is also a thing with things like college letters and logos and things like that, right? There have been cases where even just the O from the Ohio State design, if it's that particular shaped O, which is there's a font style called,
right, there is university, I think,
university font or athletic font or something, but the point is, if you do an O, well, guess what? The Ohio State University owns a trademark for the letter O in that context. And so, you have to be cautious and careful about that too.
I've heard of instances of the NFL coming after, or NFL teams coming after people for using particular color patterns.
Yeah.
That are their team's color patterns. And so, you just have to be careful. If you think maybe I'm infringing, then then just let it go. Do something else.
Yeah. It is important to remember that the design of a garment is not something that is protected, the shape of the pattern of making the garment. So again, that's the sort of the recipe in a crochet context for this many rows of this many stitches and that kind of thing. However, the aesthetic components of a design. So if you were to make a knockoff version of a sweater that has a particular zigzag check pattern or something like that, and that is, let's say Burberry makes that in the real world, commercial world, right? They might have a claim there because now again, the color scheme and that's aesthetically original, even though it's part of the pattern of the garment. So the shape of the garment, this is a case involving cheerleader uniforms, where the shape of the A-line little sweater dress was not protected, but the chevrons on the front were.
Interesting.
So something else to keep in mind as you make patterns.
Yeah, that's really interesting. And I think, the particular issue that we're talking about that's happening on TikTok right now with this infringement is the reason this particular pattern is going viral, I believe, is because the way the finished product turns out, which you could make any, I'm just going to say, I'm just going to use rectangular blanket as an example. You make any rectangular blanket, but the particular way that when you use this pattern, your rectangle blanket comes out in terms of the design created by the stitches, I think could be sort of a signature thing. I don't know. I'm not sure. And you'd have to take a look at it to be able to answer that for sure. But
but that's the kind of thing we need to look for. And that's why, if it was just all white yarn and the same stitch all the way across, there's nothing original.
Right.
So is that original sequence of stitching that results in a particular look and feel to the thing, that might be something that can be protected.
Yeah, I've been thinking about this as I'm watching people share their finished products online, and I'm like, anybody could make this generic shape, but it doesn't look anything like this particular pattern looks. It's like, I told my husband, I'm like, it's just the perfect design.
Yeah.
So anyway, let's see. Last question before we wrap things up. I always draw / sketch out my plushie toys that I base my patterns on. So she creates a sketch and then she does the design.
Sure.
Would that be protected under copyright? So her sketches that are like pre-designed sketches.
Your sketch would be protected insofar as anybody who copies the sketch would be infringing. But I guess to an extent, then your finished product of the crochet would be a derivative work of your sketch. But I don't think it goes beyond somebody just, reproducing your sketch. So that they would have to do their own.
Yeah.
And
so the sketch itself is, but the idea is not.
The idea of a dog, a beagle, who lies on top of lying on top of a doghouse takes it from idea to particular expression, right? But theoretically, you could draw a different beagle or a different breed of dog lying on top of a doghouse. I don't know whether Charles Schultz Enterprises would care about that or not.
Right.
I think they might have a case. So,
right.
If you took Goofy and put him on, or Pluto and put him on the top of a doghouse,
now you're in double trouble.
Well,
maybe
you've taken on a couple of big entities. Yeah. An interesting gag, actually.
So,
actually, that's another point we should mention real quick. Parody is a part of the fair use defense in copyright. So if what you're doing is making fun of that original design, some social commentary kind of a thing, and really using it as a poking fun, that might be considered fair use and therefore not infringement. I don't see that coming up too often in the crochet, at least not in the crochet pattern, but it may be in the design that's embodied in the pattern.
Sure.
You could see something like that. So, we know that Nike doesn't make crocheted sweaters with swooshes on them.
Right.
especially ugly Christmas sweater or something like that. But
Uh-huh.
so theoretically, you could put a swoosh in. I better not say that out loud,
Yeah.
but you know what I mean.
No, don't do that.
Don't use the swoosh.
Yeah.
Too big of a brand.
So this particular person says, I like to take a photo and design items. I think you need to specify, is this your own photo or someone else's photo? And then asking, is that infringing? So I'm guessing if it's someone else's photo and you recreate it as a blanket, replicating that photo of someone else's photo, I would assume that is infringement.
Yes.
Okay.
And another possible interpretation of this, and maybe the person who posed this will clarify, but if it's taking a photo of something out in the world, like a sculpture or a toy in a store or something like that, you're also, the photo itself is also infringing on the design embodied in that thing that you're ultimately reproducing. So it's a little bit of a tricky, not tricky. It's a good idea not to do that. Use the photo for reference, sure, but try to make it your own. Originality is really the way to go. Obviously, we have patterns so we can reproduce things, but if you're making patterns, don't copy other people's designs to do it.
And that's basically what it comes down to. We call ourselves creatives. Let's be creative.
Yeah.
And
there's more value in that anyway.
Like everybody can make a hat, but make your own, create your own, format the stitches you want to, do your own math, use your color combinations the way you want to, and make it your own. And then you don't have to worry about things like this.
Yeah.
Take the stress off yourself.
Yeah. Unfortunately, the world is full of people who aren't applying their creativity, and their creativity is figuring out how to knock something off rather than make something original. And we all see those products on Amazon and on Etsy and things like that. And I know we often do kind of recognize, oh, that's not the actual original. So.
Right. Yeah, I think it does come down to also your reputation of, if you're, I go to certain people's Etsy shops and I see their patterns, I see their designs, and I'm like, oh, I know who designed that originally. I know who designed that originally. I know who designed that originally. And they're basically building a business out of taking other people's designs, rewriting the pattern themselves, and then sharing it. And it's like, I don't see your voice anywhere in this.
Yeah.
These are all other people's voices.
Since we're talking about Etsy, there's one other thing I should just mention. For if you have original designs and patterns that you've created that people are copying, and you can identify that it's Etsy or eBay or wherever, the Digital Millennium Copyright, the DMCA, does give you the right to issue a notice to the hosting site to take down that work. You have to identify your copyrighted work and where it is. And then in order to prevent themselves from being sued for contributory copyright infringement, they will have a policy in place that requires that they take it down quickly. Then the other party gets a chance to object and explain why it should be put back up. And fair use may be one of those defenses, or there is no real copyright, or that isn't copyrightable, or they're not there's lots of defenses. It gets put back up, and then it's left to the two parties to duke it out in court or whatever. But oftentimes, it just isn't worth the fight for the infringer to come back and defend themselves. And so they'll just it depends on the work, of course. But so that's another remedy that's available to copyright owners.
Awesome. All right. So coming down to Beth says, I really need some advice about all of this. I really need a consultation. Do you do consultation work? Are you taking on new clients? And I do have all of your links in the description. They'll be in the show notes as well for people to get a hold of you. But what would that look like?
So I do consultations, and I am taking on new clients. I don't do very much in the world of fashion and crafting like this. Most of my work is with creators in film, television, live theater, podcast. I do a lot of work with podcast creators and things like that. But if you've got questions, I'm happy to have a conversation and see if we can figure out where you ought to go and what needs to be done. And if it's not a good fit for me, then maybe I know somebody I can refer you to. But
awesome.
And I know there's a handful of lawyers out there that are also crochet enthusiasts who may be a good choice as well.
Interesting. That's great. Yeah, that'd be awesome. I should do a little search and see if I can find those
how I
people
found
as
out.
well. But that's really great. Okay, so like I said, you can find Gordon's links in all of the places in the description. It'll be in our blog post. It'll be in our show notes. But I hear you have a webinar coming up. Do you want to tell us a little bit about that? That link is also in the show notes.
Yes, thank you so much. It's a business and legal fundamentals for online course creators, coaches, and mastermind owners. Really, any kind of online digital entrepreneur it will get a benefit out of this. I'm going to share some of the common mistakes that folks make and the ways to avoid them, so you can have a business that thrives and is protected and gives you a pathway to making some profit. You can come on over to webinar.easylegalbrands.com. That's letter E, letter Z, legalbrands.com. And sign up. It's coming up this Thursday, the 12th. So looking forward to that.
Okay. All right. So Thursday, December 12th. Check that out. Grab the link. We have a clickable link down in the description. I hope you'll join. Those of you, I know bunches of you are creating courses and kind of adding on this revenue stream to your business. So it might be the perfect timing for you to hop on that webinar and learn what you need to do before you do it wrong. So
the end of the year is coming, and if you have a corporation or an LLC, there's a couple of steps you really have to take before the end of the year. Well, there's been some court movement on some of these things, but and there's a couple of things that it's a really good idea to take right at the beginning of the new year. So this is the best timing there could be for this.
Wonderful. Thank you so much for making that available, and thank you again for being here. This was so helpful, and bring some clarity to. I did a podcast last week kind of giving my opinion and my research that I've done, but I'm like, I'm not a lawyer. So
did I mostly corroborate your opinion?
Mostly, yes.
Okay, good.
I mean, there are things that I would prefer.
Yes,
were copyrightable, but of course everything has implications.
Yeah.
And so I'll leave that up to the actual lawyers. So again, thank you so much. I hope you have a wonderful rest of your day. And thank you everyone for being here. We'll be here again next week to talk about some more crochet business tip stuff. So, all right, take care. Thanks so much. Bye.